Now, this might be the most important video I'll ever upload, so please watch it through to the end and share this information with anyone you know who's getting fed up with what the police in this country are doing. I see a lot of confusion over what the law actually is, and as someone with a degree in law, I feel I'm fairly well placed to explain. The first thing I see a lot of confusion over, from both the police and their opponents, is common law. The UK has a common law system which is developed throughout the history of England. What this means is that in the UK, the law isn't just what's written in the statute books. You can't just pull out a book called the law, open it up, and have all of your answers about the law. The law is developed by the courts and various legal decisions by judges being followed. In fact, the general principle underpinning common law is that of stare decisis, meaning let the decision stand. So past decisions by courts are followed in future cases, and these decisions by judges flesh out the law. Today, when Parliament passes a statute, that statute doesn't contain all the answers as to how the law actually operates in practice. Basically, the statutes are a skeleton and the courts provide definitions to flesh out the law. For example, at the moment, coronavirus regulations are painfully insufficient in providing definitions.
I don't have that definition at hand.
And we have no idea how the law can be applied or how it should be enforced.
Until this got probably tested in court, I can't give you an answer.
Yet it doesn't stop know-nothing coppers trying to make up their own interpretations.
Because you being here, after I've asked you to disperse and you don't go, that negates your reasonable reason.
And knowing absolutely nothing about common law.
Supreme Court, there's no Supreme Court.
No, because if you want to see an example, take a look at an impromptu interview I did with a police sergeant at an anti-lockdown protest.
I stand outside protests outside abattoirs because people think it's wrong to eat meat. I stand outside protests for people who feel that...
But you don't disperse them. Look for the video on my channel titled The Calibre of British Police. In fact, whole areas of our law exist solely in common law. For example, despite very brief codifications in the Offences Against the Person Act 1861, assault and battery are both common law offences. Speaking of assault and battery, most people actually get confused and assume that touching somebody else is assault. That would in fact be battery. And battery can be even the slightest touch, and even just the touch of clothing, as established in the case of R. and Thomas, 1985, so long as the application of force was greater than the ordinary jostlings of everyday life. That definition was provided in Wilson and Pringle. So, what is assault? Assault is causing another person to anticipate unlawful force. For example, if you pointed a knife at someone. Now, you can negate your assault by qualifying it, as established in the case of Tuberville and Savage. This was a case in 1669 which still holds up and is taught in law schools today as one of the key cases for assault. And in this case, the defendant put his hand on his sword hilt and said to the plaintiff, "If it were not Aziz's time, I would run my sword through you." Of course, it was Aziz's time, meaning the travelling courts were in town, hence the qualification negated his assault, and he was acquitted. So a modern day example would be using aggressive body language towards a police officer and saying, "If we weren't in a tier 4 area, I would slice your throat wide open and laugh as you choke to death on your own blood." If you're in a tier 4 area, that threat is perfectly legal to make, so long as you qualify it as such. Just don't shout it, as the copper might get you on breach of the peace. To be safe, whisper it. All that matters is that you aren't breaking the law and that the police feel a sense of impending dread and intimidation. Bear in mind, we're only treating the cops as they treat us. They use terrorist intimidation tactics all the time. It's why they arrest people at peaceful protests, rough them up, and hold them for 23 hours and 59 minutes and then release them without charge. There's nothing to charge them with. They're not operating in good faith. They're using terrorist intimidation tactics to scare people. The police no longer uphold the law. They uphold the interests of our criminal government, political class, financial elite, and big businesses. The police don't even care about the law. And they apparently don't care about their own word either. Every officer has to take an oath when joining the force. Let me read part of that to you now. "I do solemnly and sincerely declare and affirm that I will well and truly serve the Queen in the office of Constable with fairness, integrity, diligence and impartiality, upholding fundamental human rights and according equal respect to all people." Let me repeat that last part. Upholding fundamental human rights and according equal respect to all people. Fundamental human rights, you say? Ever heard of the European Convention on Human Rights? We signed on to that at the end of the Second World War, supposedly to prevent a totalitarian state that abuses human rights, but that's neither here nor there. Article 11 protects our right to freedom of assembly, and this is codified in national law in the Human Rights Act 1998. Both national and international human rights legislation recognises the right to peaceful protest as a fundamental human right. So are those officers who try to disperse peaceful protests breaking their oath? Yes, I'm not going to sugarcoat it. These officers are all breaking their oath and they're a disgrace to our nation. I mean, it wouldn't be illegal for a member of the public to place one of these cretins under citizen's arrest. Just make sure you treat police with all the care and respect they treat us. Never act at all aggressive and never use excessive force, just as they're never aggressive and never use excessive force when arresting peaceful protesters. I'm sad that it's reaching this point because this will eventually escalate into civil war and many people will die, but hey ho, we can blame the sheep and their unquestioning acceptance of COVID-19 hysteria for getting us to this stage. The least we can do is try to give the police a taste of their own medicine. Or police, as many of these coppers we're seeing at protests are in fact private security contractors. All perfectly normal, I'm sure. Now, another important point is about holding the police liable. Firstly, these coppers wearing their uniforms and following orders are presumed not to be personally liable. Additionally, there's an assumption that, at least for the purposes of tortuous civil liability, the police are not liable at all. This arises from the case of Hill and Chief Constable of South Yorkshire Police, which holds that it is generally not considered fair, just and reasonable to impose a duty of care on the police. Marvellous! But of course, as a barrister once told me, law is just procedure, and there's always more than one way about it. In this case, we have a workaround in the law on vicarious liability, i.e. employees following orders and the employer being held liable. Now, we've established that if you want to sue a cop, the cops won't want to hold the police force liable. But the law around vicarious liability is that the employee is personally liable and not acting on behalf of the employer if he is acting beyond the scope of his employment. We can see this in the classic 19th century case of Joel and Morrison. Swearing to uphold human rights and then attacking peaceful protesters certainly constitutes an act beyond the scope of employment, especially if you're demonstrably disregarding the oath you swore in the course of your employment. Hence, the police just might be personally liable. Personally liable for what, you may ask? Well, for one, trespass against the person and wrongful imprisonment. Kettling protesters constitutes unlawful imprisonment, as the police can either arrest someone or they can let them go, but police cannot just hold you in one location without charge. It's unlawful, constitutes the tortuous offence of trespass against the person, and can get you a nice payout if you decide to push forward with a claim. Another area the police seem to be confused about is fines, believing they can just waltz up to somebody and issue them with a £10,000 fine. Well, the Bill of Rights 1689 says otherwise. A fine is only valid after conviction. You can't just walk up to someone and fine them. We have a thing called courts in this country, and we have these things called trials, where the evidence is examined and both sides are heard prior to a conviction. They're not exactly fair or impartial trials, but trials nonetheless. The police aren't judge, jury and executioner. Another point of confusion, judging by the arrest of Louise from the Save Our Rights group after she pushed over a plastic barrier, is criminal damage. Now, damage doesn't need to be permanent, but it does require some expense to repair and must be more than trivial. In the case of a juvenile, and R, 1978, the court heard that the defendant spitting on a police officer's jacket and the officer needing to pay for it to be cleaned did not constitute criminal damage. Now, I'm just saying, if anyone wants to take down those barriers they put up around Trafalgar Square to prevent gatherings, so long as you don't physically damage the walls and they can be put back up, you're not committing criminal damage. Trafalgar Square is not closed and those barriers shouldn't be there anyway. A couple of Range Rovers and some rope will have those barriers down in no time. And finally, I want to discuss with you the criminal defence of self-defence. Now, this is partly common law and partly codified in various statutes such as the Criminal Justice and Immigration Act 2008 and the Criminal Law Act 1967. In fact, Schedule 3 subsection 1 of the Criminal Law Act says that a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders. So next time you see an officer pushing over an old lady, Don't be afraid to use a little force. Now, the two requirements for the use of force are that it must be necessary and proportionate. Regarding necessary, this is based on a subjective test, i.e. whether the defendant believed the use of force to be necessary. In the case of Gladstone Williams, 1984, a man wrestled another man to the ground after he witnessed him attacking someone, when it turned out he was in fact attacking a suspected mugger, so the use of force was not necessary and was in fact counterproductive. However, as he believed the use of force was necessary, the defence of self-defence was successful and he was acquitted. Now, regarding proportionality, Section 76 subsection 3 of the Criminal Justice and Immigration Act establishes that this is also subjective. In fact, subsection 7 goes further, saying that a person probably won't be able to weigh up the proportionate response in the heat of the moment, and that simply believing force to be necessary suggests that the force was proportionate too. So there's a very lenient standard when it comes to proportionality, and a police officer trying to unlawfully arrest you at a peaceful protest or unlawfully holding you in a kettle should be enough for you to use whatever force you deem necessary in the heat of the moment to protect yourself and others present. Another point to note is that you're under no obligation to retreat, so simply remaining after you've had the opportunity to retreat doesn't nullify your self-defense, as we established in the case of Bird 1985. And perhaps most interestingly when you look at the case law is the Attorney General's reference case number 2 of 1983. In this case, a shopkeeper made petrol bombs and held them in his shop during a riot. He was then charged for the possession of the weapons, but he was able to successfully use self-defense to avoid conviction, as the possession constituted preparation for attack for the purposes of self-defense. I'm not suggesting anything here myself, but what I am saying is that the law states that self-defense also covers the possession of petrol bombs. I hope you have fun with this new knowledge, and I hope to see things changing direction at these protests soon. Remember, there's more of us than there are of them, and we will never get our lives back if we do nothing. We have to take our lives back, and if we don't succeed, we'll have nothing to lose. God bless you all. Except all you 77th Brigaders watching. There's a special corner of Gehenna reserved just for you. But for the rest of you, God bless you.